Welcome. We hope this broadcast finds you healthy and safe. Thank you for tuning in to MSK's video pop-up series, where we discuss late-breaking news and issues that affect your business during these uncertain times. Today, we'll be hearing from Jonathan Turner, partner in MSK's Labor and Employment Department. As companies prepare to reopen, there are mounting questions on a wide range of topics. Today, Jonathan will be specifically addressing the question of employer liability when family members of an employee contract COVID. Over to you, Jonathan.
Thank you. Good morning. As Doug mentioned, this is next actually in a series of short video presentations by Mitchell Silverberg and Nupp to assist our clients and the business community as we try to keep up with and understand the flood of laws and regulations that are coming at us daily at an almost unimaginable pace. In earlier videos, video pop-ups, Gene Nogris, another partner here at the firm, had discussed issues regarding insurance coverage for business disruptions. Stu Ross talked about the constantly evolving federal guidelines and the various state and local laws and emergency orders intended originally to flatten the curve, so to speak, and apparently now to pave the way to reopen businesses and get people back to work. And Jeremy Mitten also gave a presentation discussing legal compliance issues relative to administering workplace screenings for symptoms, temperature checks, and other permissible safety measures to put in place as people begin returning to the workplace. So in this presentation, I'm going to discuss at a high level some of the employer liability and legal exposure issues likely to arise under the workers' compensation laws, the occupational safety and health laws, and in third-party lawsuits that might be initiated by family members of employees who may have contracted the virus from the employee's exposure to that virus, the workplace. So let me start by giving an overview of the workers' compensation law. Workers' compensation is a form of no-fault liability for work-related injuries by an employee. And when I say no fault, it means just that. Employees do not have to prove that the employer did anything wrong, either intentionally or by failing to take appropriate precautions to prevent the injury. The only thing the employee needs to show is that the injury actually occurred or happened, is real, and that it arose out of or in the course and scope of employment, work-related injury. Workers' compensation is a compulsory form of insurance, and by that I mean the law in every state in this country, I think with the exception of Texas, requires employers either to carry that insurance or some form of self-insurance to provide for a work injury benefit. So what if the employer doesn't carry that insurance? Well, in California, it's a misdemeanor. It's punishable by up to 1 year in jail. There are stiff penalties and fines. We don't go into details about those other than that I assume you don't want to incur those if you can avoid it. And the labor commissioner here in California can actually issue an order, literally shut down your business, prohibiting you from using any employee labor until you obtain coverage and proof of coverage. There's one other consequence of not having this insurance as an employer, and that is the employee can then sue in court for any injuries he or she has sustained from the workplace. Now, you might ask, what's the significance of that? Because after all, lawsuits, anybody can sue anybody, right? But the statute, the workers' comp statute actually says you can't. It's a work injury. An employee cannot sue as a general rule. So what that means is the employee's sole remedy is in under the workers' comp statute, and that's advantageous to employers because even though the employee doesn't have to prove fault to recover, there is a cap, a statutory cap on how much the employee can actually be awarded for work injuries. So if the employer doesn't carry insurance, the employee files a lawsuit. Yes, he or she has to prove fault, but on the other hand, there's no cap which means the sky is almost the limit in what the employee could recover, depending on how egregious the conduct is and how serious the injury. One other point I should mention here, and I'll come back to it later, is general rule. When an employee has sustained a work injury and is confined to pursuing that claim only through the workers' comp system, that employee's family members also have no recourse to sue in court based on that same injury. That's a general rule. And by way of example, family members can't bring a claim for wrongful death based on a death that occurred as a result of a work injury. They can't bring a claim for emotional distress from witnessing the effects of the injury on the employee if it's work-related. So I'll come back to litigation by family members in just a moment. I want to shift gears and talk about, give you a general overview of the OSHA laws. OSHA is the Occupational Safety and Health Act. It's a federal law that was enacted in 1970, and the law imposes safety standards on most workplaces and stiff penalties on employers for failing to comply with those standards. And the federal law works in partnership with a number of states who've been authorized under the statute to have their own state-run programs for which they receive federal funding. And California has such a program. It's administered under what's commonly referred to as Cal OSHA. And under Cal OSHA, employers are required to, at least employers in the state of California, are required to have, among other things, a written workplace injury and illness prevention program designed to protect employees from workplace hazards, including infectious diseases, which also includes diseases that are transmitted through the air, COVID-19. So that law has been in place for a while, but with this recent pandemic, Cal OSHA has taken upon itself to issue some guidelines. Under these guidelines, employers are required to determine if COVID-19 infection presents a hazard in their workplace, and if it does, employers have to implement infection control measures, including applicable recommendations from the Centers for Disease Control and Prevention. Now, if any of you need or would like access to those guidelines, then you can reach out to us. We have a team of people at our firm that can respond to these kinds of inquiries in fairly quick turnaround time. So, when an employer fails to take appropriate safety measures or precautions to protect their workers, what does that mean as to third-party lawsuits by family members? Remember, the general rule is that neither an employee nor a family member can sue in court based on the employees having sustained a work injury. Compensation for those injuries confined to the workers' comp system. So where does that leave COVID-19 infections and the transmission of that disease from work to home? How does that fit into the exclusive remedy framework of the Workers' Comp Act? Well, that question is complicated further by the fact that on May 6, Governor Newsom signed an executive order that creates a rebuttable presumption that employees who test positive for or are diagnosed with COVID-19, they're presumed to have contracted the virus while at work if four conditions exist. The first condition, the employee must perform work at the employee's place of business on or after March 19 of this year. Secondly, the employee must not have been working from the employee's own home or residence. Third, the employee must have tested positive for or was diagnosed with COVID-19 within 14 days after he or she performed work at the employee's place of business. And lastly, the COVID-19 diagnosis must have been issued by a physician licensed in California, and the diagnosis must have been confirmed by further testing within 30 days of the date of the original diagnosis. So employers are going to want to, in light of this order, do a cost-benefit analysis. We've been getting some questions on this as to whether to challenge these presumptions. On the one hand, allowing the presumption to go unchallenged will bring the employee into the fold of the workers' comp system with the, the advantage of having the cap on recovery by the employee. On the other hand, workers' comp premiums almost likely are sure to go, but they're going to go up anyway, given the widespread nature of this disease, which doesn't appear to be subsiding anytime soon. But if you have workers' comp insurance and you talk it all to your adjusters and claims representatives, I think they'll tell you that the more frequent history of a claim that's filed for work injury, and the more frequent those claims are found to have merit and there's some reward, usually means they reassess your premiums and you're going to end up having to pay more. There's one more thing to be thinking about here if the governor's presumption were to go unchallenged. What does that do for family members who are exposed to the virus by reason of the employee being presumed to be a carrier? Can they sue the employer? And we think the answer likely is yes. There's case precedent for this in at least 2 California Supreme Court decisions. First one decided in 1997, Snyder versus Michaels Stores. And in that case, the plaintiff was actually in utero. She was in the womb at the time that she sustained the injury. And what was the injury? Well, her mom had been coming into the workplace and was exposed to toxic fumes in the workplace. And the court held, I should say the plaintiff then, after she was born, sustained or apparently had some major brain trauma and injury. And so the lawsuit was to recover for that. The court held that where family members are concerned, even though the general rule is if those members are suing on the basis of a work-related injury, i.e. the mom being exposed to the fumes here at the workplace, there are recognized exceptions to that rule if the alleged injury for which family member seeks to recover is one that is neither based on or legally dependent upon injuries suffered by the employee. In this case, I don't remember if the mom had serious injury beyond headaches and maybe other general discomfort. I don't think the court got into those details because it didn't think that was all that relevant to her daughter's action. Her daughter had her own separate, legally independent injuries, separate from the mom's, and therefore was allowed to proceed in right. The second case is a California Supreme Court case that I mentioned, Castner versus Superior Court, the 2016 case, a more recent case, which even though it wasn't a workers' comp case, in some ways it had facts that are closer to the COVID-19 circumstance. It's an asbestos case where the court held employers have a duty to members of the employee's household to prevent exposure to asbestos fibers which the employees might carry home on their person or clothing from the workplace. Again, I mentioned when you sue for this kind of action, you have to prove fault, but the court didn't find any problem establishing that. They discussed all the OSHA regulations out there that address these hazards, particularly regulations regarding asbestos. And so this was a case where even though workers' comp was not at issue, it still stands for the proposition that third-party family members who are injured by things based on what an employee might have been exposed to at the workplace is a viable lawsuit. So we see from these cases, the question isn't whether the family member could sue, but what would the person have to show in the lawsuit to recover? Fault in the form of either intentional conduct or negligence by failure to take appropriate precautions to prevent the injury. From that, it's not a stretch to argue that the failure to take appropriate precautions in the workplace to screen for and prevent the spread of the COVID-19 virus establishes fault on the part of the company. And that it's also reasonably foreseeable that the failure to take those precautions could result in injury to family members of the employee's household. So the takeaway and overarching recommendation here Employers should use extreme caution, take all steps necessary to provide a safe working environment. And for that, I encourage you to look at the prior video presentations by Sue Ross and Jeremy Mittman, where they talk about some of those things. So I think that's our time's out. So Doug, back to you.
Thank you, Jonathan, and thank you all for joining MSK's video pop-up series today. These video sessions are intentionally brief and hope you find them useful. We do not provide for Q&A format. If you do have questions for Jonathan, his information is currently on screen. And if you need any additional guidance from anyone else on MSK's Reopen Rapid Response team, you can easily email us at reopen@msk.com. So keep an eye out for additional pop-up videos in the coming days and weeks. And more importantly, please continue to remain healthy, remain strong, and remain hopeful. Thank you and goodbye.